This Honorable Court of Appeals is now.
Good afternoon. On behalf of Judge Bennett and Judge McBrayer, we welcome both attorneys to this oral argument, which we are live streaming to fulfill our obligation to have open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes to argue, and Mr. Mayor has reserved 3 minutes for his rebuttal. Unless there are any announcements, I will ask Ms. Lindsay to call the case.
Leanne Polster versus Russell Joseph Polster.
All right, counsel, you have the floor.
Thank you, Your Honors. Your Honors, basically, this is a issue regarding a divorce that went through on an uncontested matter. My client was a pro se litigant at the time. This was at the time of COVID, when the courts were normally closed and proceedings were done in a different manner than normally done. We bring several issues before the court today. The first is the entry of the final decree on the date that it was entered. There was a notice of hearing sent out for that day. The notice of hearing was received by the pro se litigant. He tried to appear at that hearing. The notice of hearing, and it's in the file, did not note that the hearing was going to be anything other than a normal hearing. It didn't indicate that it was going to be on the pleadings and that no one was being allowed to be present.
Counsel, I can hear you, but it would help me if you spoke up a little bit more.
Thank you.
Thank you.
So with regard to the initial final hearing of divorce, in this case, my client appeared at the courthouse, was not allowed in because of the COVID restrictions and the courts being not open to the public in general. And it's our position, based on Barnes v. Barnes citing Harbor case, that essentially a court cannot enter a final decree on an uncontested divorce if one party withdraws their consent to that divorce.
Wait a minute. Where did he withdraw the consent?
He could not get into the court to withdraw his consent. So he filed a motion to continue that hearing pro se, again, in his own pro se language. I think the court's got that. It's called, he titled the extension to final notice, final hearing on an uncontested divorce.
Okay, where does it say he withdraws his consent in that document?
Well, he didn't say it in the terms of I withdraw my consent. He said that essentially I want this continued and you to order us to go to counseling. And then after counseling, if she still contends to go forward with the divorce, then I will agree to it. So there was a condition precedent to, at that point, to going forward with the divorce, was that she attended counseling with him. And so I think that, you know, when you have a hearing and it's set for hearing, there's a final hearing, and you can't get into the courtroom and you're pro se and you're told you need to write something up, you don't know what to write. The judge didn't have the opportunity to question him. Normally, if you show up at a final hearing, the judge would question you, do you want to continue with this? Or are you trying to contest this? Do you want a lawyer? That type of thing. But here, he wasn't even allowed into the courtroom to do any of that.
Well, that was because of COVID, I assume?
Yes, Your Honor.
Well, was the hearing supposed to be on Zoom or some other thing?
No. The hearing, the notice for the hearing just simply said that it was a hearing, and the date, time, and place of the hearing at the courthouse. So there's no indication.
Didn't the rules provide some mechanism, though, for a party, if they wanted to request a hearing, and I think it would be via Zoom, that they could do so?
Yeah, the rules, that the notes that were sent out to all the attorneys through the Bar Association did indicate those type of things. But again, he's a pro se litigant, and the notice of hearing he got didn't indicate any of that. So he just shows up.
It had to be where the local rule that had been adopted then.
Right, and there was more than, and I think you'll look at Mr. Gursky's in my briefs, you'll see that there's different local rules for Chancery and Circuit Court, and different procedures for doing each one of those. And this was a Circuit Court judge sitting for Chancery, making it even more confusing. But again, my client was a pro se litigant and didn't have access and did not receive any of those memos from the court.
Well, you know, pro se litigants are supposed to follow the rules, and there's some obligation for him to become informed of those rules, is there not?
Well, there is, and there normally wouldn't be, but these are rules that were sporadic. I mean, there's multiple rules published constantly, and we as lawyers only got them through the bar association, the local bar association. So it wasn't like something that was easily or readily available to a pro se litigant. And when the notice of the hearing doesn't indicate anything with regard to that, then how's pro se litigant to know any better than to show up at the time and place of the notice? And I think that's a due process.
Yeah, but I thought he might try to notify opposing counsel, though.
I can't speak to that, why he determined not to or to do that. Of course, we didn't have an evidentiary hearing, so I don't know specifics of why he didn't do that.
Did he call the clerk's office?
Yes, that's how he showed up that morning. And that's when I think that my understanding is there's some kind of communication. And they said, you need to file something. The judge said, you need to file something. And that's when he sat there and produced this document that same day and filed it with the court, trying to get the hearing extended.
So did he only, oh,
Go ahead.
Did your client only decide then that he wanted to repudiate the marital dissolution agreement the day of the scheduled hearing?
I don't know that. There was nothing that was in the record about that we placed in the record that I know about the repudiation of the marital dissolution agreement, the timing of when that came into his head. It had it when he got, I think his position is when he got that notice of hearing, it was his intent, once he got that he was going to appear at that hearing.
But that makes it puzzling for him not to include that in his writing. You know, if that's the reason he showed up that day, to tell the judge, I'm not pursuing that, it seems like that would be front of mind. He would have put that in his writing that he filed with the clerk's office.
Well, and I guess we're looking at a pro se litigant, taking them as liberally as we can. And I think he said on here, I don't care about that. At this point, I feel she's compelled to follow through with the divorce. All I care about is saving my marriage to my God-given soulmate. I beg you to please grant me this request. That sounds to me like he's not thinking they have irreconcilable differences, and he does not want to get divorced from her that day.
So what he says is, all I'm asking for is counseling, etc. He doesn't say I'm asking for the MDA to be withdrawn. I'm withdrawing my consent. Sounds more like a motion of a continuance.
Yeah, and I guess it's both, correct? I mean, he's withdrawing his consent on the divorce being entered that day, and then he's putting a contingency in there that after we complete this 3 months of counseling, if we decide that we still want to go forward with the divorce, then her attorney can keep the papers on file. So again, we're talking about a pro se litigant, and I think you can, just by reading the pleading, seeing his state of mind at the time, and that kind of dovetails into some of our arguments about whether the MDA that was entered was conscionable or not. And so I think that when you start looking at what he said in his pleadings, that his understanding was, in this case, that she said, hey, if you sign all these paperwork, then once you sign that, then we'll talk about working things out.
And is he asking, he's not asking for a hearing in this extension pleading, is he?
He's asking the court to extend or not enter the divorce, essentially is what he's saying.
Right. So he's not asking, he hasn't asked for a hearing here. He's asking for some sort of extension.
Right. And I guess he's asking the court to order something too. So again, he's a pro se litigant. I don't know that he could be held to this, I think we got to look at what is the intent of this document. The intent of this document is clearly that he does not want to divorce this woman on this day, and he doesn't agree to divorcing her without this counseling. And then I think you need to read into that also that he has been, according to his pleadings, There wasn't any evidentiary hearing and no testimony or evidence taken, but according to his pleadings, she was telling him that if you do this, if you sign this MDA, I will work this out with you. So he signs the MDA. And according to him, she does not attempt to work things out with him. She does not do anything that, anything that's toward that. And he signed this MDA, he says, based on the fact that she says, I'm going to work things out. Let's just sign this as some type of, in his mind, good faith thing showing that you really want to be with me. You'll sign over every piece of property you own and every asset you own and pay all the debt and prove to me that you still want to be married to me, is essentially the way I think he saw it. And if you do that, then I'll start talking about whether we're going to stay together or not.
I'd like to ask you about a couple of things in your brief before your time is up here. You raised some, I guess I would call them contractual defenses like duress and incapacity. Where were those raised in the trial court? What pleadings were those raised in the trial court?
That was the article, the motion, the Article 60 motion. I mean, when he put all those arguments in there, and you'll see that he says in his pleadings that he relied upon her, and that he was in shock and he was in depression at the time this happened, that they'd been married and raised 2 children, I think married 20 plus years, and he did not anticipate or see any of this coming. 28-year marriage. He says in his pleadings he was depressed and
so it's the motion to rehear or reconsider or alter and amend. That's it. The motion to alter and amend.
Yes.
Okay. What about unconscionability? I didn't see unconscionability mentioned anywhere until we got to the brief.
Well, I think the unconscionability argument goes into the court's responsibility under the statute to review these things to determine whether they're conscionable to begin with. And I think the argument here is that if you look at the division of the assets here, it's so incredibly one-sided. I think I put a little in my appellate brief. I put in a little chart there. Mr. Polster got no alimony. Mrs. Polster got $30,000. Mr. Polster got no real property. Mrs. Polster got $169,000 worth. Mr. Polster signed over $220,000 worth of retirement accounts to her. He got zero in his retirement account. He got a vehicle worth $11,000. She got a vehicle worth $13,000. He assumed debt of $22,819.24, and she assumed no debt. So essentially, he came out with a negative $11,699.24, and she came out with $432,000 and $432,000 in assets. And I think that when you look at the standard, would any person, any reasonable person, think that was a fair division of assets from a 28-year marriage where his wife filed for divorce against him?
My question about that was when this was raised, and I didn't see the word unconscionability anywhere.
It was not. I didn't file the motion. I just thought that it's a general. It generally falls within whether the court should have reviewed the equitable nature of this.
All right. Thank you for your argument. We'll hear from you on rebuttal. Mr. Gursky, you have the floor. Be sure to unmute.
May it please the court, Steve Gursky of the Montgomery County Bar, and I represent the Appellate Leanne Polster. This is a divorce that involves a 28-year marriage. Mrs. Polster worked for the school system. Mr. Polster had a job working as a commercial industrial for services company, in the electrical field. The parties in this case had ultimately negotiated a marital dissolution agreement that essentially resolved every issue that was in dispute between them. It was a full, complete, and final distribution of their marital estate. And consistent with the local rules that were in place at the time, this case was said to be heard on the pleadings. That's how uncontested divorces were set to be heard. And on the date that this was set to be heard, that's the first time that Mr. Polster stepped forward and initiated any kind of, concerns or complaints about what he had signed. And on that date, he filed his document that we were discussing, basically asking for, a continuance of the hearing, which the trial court denied. Within that filing, it's significant that, he expressly stated that he didn't really have any concerns about the distribution of property. That wasn't something he was worried about. The only thing he was worried about was he was hoping that his marriage, would continue, that the court would order some kind of marriage counseling. His filing, the one that he did on his own, is completely devoid of any assertion that he was somehow tricked or duped or defrauded or, misled, or there's no statement that he was incompetent and didn't know what he was signing. But then thereafter, Mr. Polster, then with the aid of his attorney, that's when he filed his motion to alter or amend, seeking relief under Rules 5904 and 60.02. And again, in connection with the directives of the Tennessee Supreme Court, the 19th Judicial District set forth a comprehensive plan on how we hear these cases in the COVID environment, and I'll call that the plan. And the plan specifically said that uncontested divorces were going to be heard on the pleadings. That's the Supreme Court approved that, and that was the plan. Now, and that's pretty much how this divorce was handled, including the motion to alter or amend that Mr. Polster's lawyer filed. So in the motion to alter or amend that Mr. Polster's counsel filed, the parties were given the opportunity to present their arguments essentially in writing, and the trial court, based upon those written papers, would ultimately render a ruling. And that's how we had been conducting business. That was the business as usual. That was SOP at the time.
So if you were going to argue in the motion to alter and amend, if you were going to argue, incapacity or something, so I was so upset, I was so depressed, I didn't have capacity, would you be expected to attach an affidavit from a friend, a doctor, someone to provide a little bit of proof?
Yeah, and that has been the standard course, but basically whatever you want the court to consider, you can put it in front of the court. And oftentimes the court would say, well, hey, there's more here than I thought. We can't do this one on the pleadings. We need to set this one for a Zoom hearing so we can take evidence. And in this particular motion, on the motion to alter or amend that was filed by counsel, it was specifically requested that it be heard on the pleadings. They had the right. Our local rules that were implemented clearly provided that they could have been heard, either by Zoom, WebEx, or they could have made a request for an in-person hearing, but they specifically asked their notice at number 45. It basically said, hey, we just want to do it on the pleadings. So it's our position that, Mr. Polster, respectfully, he waived any, due process arguments that he's asserting, because he consented for the trial court to rule upon his motion based upon the pleadings. And based upon what was before the trial court was well within its discretion to review and decide this post-trial motion on the written papers, as that was the manner and mechanism that was approved by the Supreme Court. And when the court did that, the trial court ultimately held that the motion didn't meet the Rule 60.02 threshold to show that there's any mistake, inadvertence, excusable neglect, or fraud. And if you look at the allegations, even of the motion to alter or amend, they're really just conclusory allegations of fraud, conclusory allegations of intentional misrepresentation, but there's really nothing to substantiate it. I think the best Mr. Polster alleges and argues is that his wife was texting him and sending him pictures sometime prior to the divorce, up until the final hearing that lulled him to sleep. And he thought that perhaps she wouldn't finalize the divorce, that he had already signed off on. That's basically the best argument that he makes in his papers. But notably, Mr. Polster didn't provide the trial court, one shred of evidence to support his theory, nothing to show that he was incompetent, under duress, missing work, seeking medical treatment, that Mrs. Polster did anything to trick him or deceive him. There was nothing that he presented. And then he goes on to say that because of her misconduct, that he signed this MDA without the advice of counsel and basically gave everything away. First off, he never really tells the trial court ever, in any of his papers, what misconduct he's asserting. There's nothing there, not a hint of, what he deems to be her marital misconduct. And then the trial court ultimately decided the motion on the written papers, as has been customary, and held that there just was no proper showing to justify the relief. And the case law that interprets Rule 60 basically says that Rule 60.02 is not intended to relieve a party from his free, calculated, and deliberate choice. Rather, such relief should be afforded in the most extreme, exceptional, or unique cases, and that's Court of Appeals case Wine versus Wine. So in this case, Mr. Polster signed a marital dissolution agreement that he negotiated, that he knew for more than a month when it was set to be heard and finalized. And he knew what that date was, and he knew that it was going to be ruled upon based upon the written papers. And even on the same day that he claims he's trying to contest it, he affirmed the entire distribution of property without making any complaint about it.
Would you say that again, Mr. Gursky, on the same day as what? He did what?
I'm sorry, on the same day that the divorce was held, on that same day, that's when he filed his pleading called extension to file. And then he said, I'm perfectly fine with the distribution of assets. On the same day that he's saying, hey, judge, don't finalize the divorce. I don't really care about the distribution of assets. Just give me a chance for marriage counseling.
Oh, he's saying that in the same document for
Yes, correct.
Now I'm with you. Okay.
How did the court make the public aware, or how would this appellant be aware of the procedures applicable in the divorce case?
I believe all of our 19th Judicial District local rules are published, on the AOC website. I believe that's where I found them. I believe that's where they're at. And yeah, I agree with Mr. Maher. They're not readily, available, but that's the trick when you're representing yourself. I think they were out there. I think they were there to be had. But the truth was, even if he wasn't knowledgeable of the rules, he filed something that said exactly what he wanted to say. It's obvious the court considered it and disregarded it. The court, was not impressed with it. And ultimately he had his full bite at the apple, because ultimately he had a very good lawyer file a motion to alter or amend for him. And he basically got to present all of his evidence to the judge that he wanted to present to the judge. And in particular, here's what the judge heard. Judge Crozier had the benefit of Mr. Polster's own statement on the day of the divorce that he's perfectly satisfied with the distribution of assets. The court was also aware that Mr. Polster signed off on this dissolution agreement, and it's in the preamble to the dissolution agreement that says the parties agree that regardless of the grounds for the divorce, this agreement is binding and shall be submitted to the court to control the distribution of their property. So the trial court also had Mr. Polster's own representation that the division of the assets and debts was equitable. That's paragraph 13 of the dissolution agreement. Paragraph 14, that the dissolution agreement confirms that the terms of that agreement will be the express terms for the divorce. So he knew those were the terms for his divorce. And paragraph 25 that he signed off on and initialed every page of the dissolution agreement, on paragraph 25, he clearly acknowledged that the agreement is fair, is not the result of any fraud, duress, or undue influence, So, he asserted all that when he signed off on that dissolution agreement. And then he further acknowledged that there was no promises or warranties or covenants or agreements or understandings outside of the written document that he signed. So he argues today, I think his unconscionability argument that, we're hearing about now that wasn't raised in trial, that was, you pointed out. He says that the division of assets was wholly inequitable, yet in paragraph 3 of the dissolution agreement, he says that the division of property is equitable. And then there's actually a specific list of who gets what in paragraph 3 of the dissolution agreement. Mrs. Polster, she took the house with a mortgage on it. And she agreed that she would indemnify and hold Mr. Polster harmless. So there's no evidence in the record as to, what the value of the house was, what was owed on it. In Mr. Polster's brief, he references that there was that has a value of $169,000, but he doesn't tell us if that's the value before the mortgage or after the mortgage. What's the equity? There's nothing there about that. Mrs. Polster was awarded a retirement account that had a value of $181,000. She was awarded 2 smaller investment accounts that had a value of about $60,000. But their agreement, the dissolution agreement, specifically provided that she had to pay off his car, her car, there was a Parent Plus loan that they obligated themselves on for their child, and then she paid off a credit card. So she paid off substantial marital debt per their agreement with the funds that she received. So they identify in the chart that was in Mr. Polster's reply brief, they identify $22,819.24 worth of debt, but all that debt was liquidated and satisfied. That was, my client paid all that debt per the express terms of the dissolution agreement. So he's putting things on there that really he wasn't, that are just kind of taken slightly out of context. So, it's our position respectfully that it's obvious from the detail of this dissolution agreement that it was negotiated, it was discussed, that there's really nothing inherently off the rails about this settlement agreement. It's not ridiculous for a 28-year marriage. She works for the school system. He has a job, working for an electrical company. It's just, there's nothing disparate about what happened here. That we think that it was a very equitable division, that the trial court expressly found, and this is one thing Judge Crozier did find of his few findings, that he said that Mr. Polster may have made a bad deal, but there's really no showing of how a soon-to-be ex-wife would overcome the free will of a 50-year-old man. So I think Judge Crozier was not impressed with any of the evidence before him, that this case was, ruled upon and decided in the customary fashion, and respectfully, we would ask that the trial court be affirmed.
I have one question. I believe in your brief you asked for attorney's fees. Is that correct?
Yes.
Now, the MDA has a provision in it for attorney's fees for a party who institutes legal proceedings to enforce its provisions. Does that apply here when he's attacking the whole MDA existence?
Yeah, I always look at that language when I argue in here. I always know I need to tighten that language up in my dissolution agreement. I think certainly if it doesn't cover under that provision, I think there's other provisions in the law that certainly would entitle us to attorney fees. We think that, my client if she had to spend money to enforce the agreement at the trial court level, she had to spend money on appeal to enforce it. So respectfully, we would think that contractual language would apply, plus the other statutory language would apply as well.
Okay. Thank you.
Thank you.
All right. Thank you, Mr. Gursky. We'll now hear the rebuttal. Be sure to unmute. I get paid extra for reminding attorneys to unmute.
Thank you, Your Honor. I just wanted to quickly respond to the issue with regard to the attorney's fees. I don't think this is an enforcement action on their part. I think that it would have an extreme chilling effect if we said that if anyone that filed a Rule 60 motion would be required, especially under the circumstances, this type of circumstances, anyone that filed those type of motions to set aside the actual contract for any reason, then that would be an extreme.
You're attempting to repudiate it, and your opposition is attempting to keep it there. So would that not be enforcing it?
No, because I think that enforcing it in the sense that if he didn't follow some aspect of the MDA, but if we're and a lot of these issues are not part of it's repudiating with regard to the contents of the MDA, and a lot of it is due process issues. That he's saying there's due process issues that stem from the court's actions rather than any actions related specifically to the MDA. So I think there's also an issue with that because I think that's one of the things he's saying essentially is this is a due process issue with regard to him trying to appear in court that day. And I think it again goes back to the court's charge to determine whether these things are equitable or fair.
Okay, what should have happened? You've got these rules out there that say we're going to do all this by the paperwork unless exigent circumstances or somebody requests something different. He goes to the courthouse, he's not allowed in, he sends in this paper. Isn't it, and it's considered by the judge apparently. So isn't that the due process that the rules give him? What else? What should have happened?
Well, he should, if he'd have been allowed to come in and appear in front of the judge and explain the situation rather than telling him he's got to try to put something in writing.
Well, that would be ex parte, wouldn't it?
No,
nobody else was there.
Well, no, the notice of hearing was there, and my understanding is they let attorneys in to the courthouse. They just didn't let pro se litigants into the courthouse. And Mr. Gursky's notice of hearing referred to it.
Do you have any evidence in the record that pro se litigants weren't allowed in the courthouse as a rule?
Other than my client wasn't allowed in. That's in this situation, he was not allowed in. And the notice of hearing did say there was to be a hearing.
Okay.
That's our issue with regard to that.
Thank you both for your arguments. We will take this matter under advisement. Ms. Lindsay.
Thank you, Your Honor.
I think we may have lost our deputy clerk, so I'm going to recess the court until 2 o'clock. Thank you, Ms. Lindsay. All right, counsel, you are free to exit the meeting.
Thank you, Your Honor.